Hey, Attorney Brian Parker here with another exciting video. This is 4th of July week, so I gave you a free PDF check sheet a couple of days ago. I'm going to give you another one just for the happiness of celebrating our perfect union. We have a free cheat sheet on how to appear in court and talk in court at the first meeting, which is the pre-trial. You've seen my video, hopefully. In fact, let me point it. Top 10 tips on preparing for court, and the video, swish. And that is a sort of a primer or prep for when you go to court. The purpose of this video and that video was to take out the nervousness and anxiety, which can really rob you of an effective performance, no matter what you do. You gotta sit your kids down and yell at them, take the emotion out of it. You gotta sit grandpa down and say you gotta take the keys away from the car, take the emotion out of it. So that's what this little PDF cheat sheet is gonna be for you. So I'm gonna give you, on my my membership website, collectionstoppersolutions.com. It's chock full of hundreds of videos, instructions, and notes and word templates to do your thing in your state. Apply your state rules and your facts. But it also has a section for free stuff. So this is going to be one of those parts of the free stuff. It's going to PDF cheat sheet, and it's sort of the sequel to my top 10 tips on how to appear in court. Let's do that up there one more time. Cindy, boom, 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 swish. So that'll have a list of tips for you attached to the video. You know what? I'm going to take that list and attach it to this video. So you got two things today, but here's the cheat sheet. You ready? Rock and roll. Okay. This again is to get rid of the nervousness of appearing in court. It's a nervous situation. I still sometimes sort of get queasy depending on the motion. I've stopped throwing up a couple of years ago, although I know attorneys that still do right before important motion. It's just a thing. It's a human thing. But as you get older and wiser and grayer, you start putting things in perspective. So I want to give you that perspective of 30 years in about 30 minutes. First, before I give you the checklist. So what I'm going to do is give you a checklist. So you sit in court, if you want to follow my approach, and you can checklist your way through the minor steps of maybe a 10-minute endeavor. But this is a security for you. I never have security as far as when I'm arguing cases. I like the court to see me without any notes. So that way I can point out that this guy needs a book to when he should be talking from his heart, that type of stuff. So, but this for you and for me, because you're setting a zone, have this checklist. So it's a checklist that you check off, okay? So this isn't a part of that checklist, but look at me today. Blue, red, blue. Blue is the color of trust. I've done the research. I used to try cases once a week. I was crazy, but I tried to get every inch I could, and I looked into colors. Green, by the way, is the worst color. It's just a natural, I don't know what it is, a makeup. But if you want to check my facts, just take a ride and look at how many businesses have blue in either their signs or in their building. It's the color of trust. Anyway, check box number 1. Again, you're laying this down at the podium. You're looking good. And the first thing you want to do is smile. Always sound friendly when addressing the court. She's having to see a ton of people, all with their problems. By the way, I don't write this on the checklist, but no phones, please. And manage your production. So before you appear, if you're doing a Zoom hearing, manage it. Practice. It's the worst. You're sitting there and the person doesn't take the mute off, and now the court gets in. It's a mess. So for the sake of everybody that's watching in the Zoom, or yourself, so you come off like you know what you're doing, practice before you play, and try to use a camera, not a phone. All right. So always smile while addressing the court. When you're talking about the other side, appear negative. Smile, negative. It's just little things that I've learned inch by inch. Anything's a cinch. Smile a mile for the court, all right? hear me yelling? Speak loudly and clearly and say, "May it please the court, I am Dorothy Debtor. I am the defendant against the debt collector." Why did I just say it like that? Well, "may it please the court" is the most respectful way you can address the court, of course. They got that position. It's hard work to become a judge and to keep it. No, not so hard to keep it. But anyway, never refer to the other side as a person, a business, a company. They are a debt collector. Never refer to the other side as a human being. Conjure up the image that gives anybody, when they think of timeshare salesman, used car salesman, debt collectors. It's the thing. It's just another small tip that this stuff adds up, all right? I know, I've done it. So this is always a debt collector. No matter what, that's a debt collector, right? So use everything you can. That's a negative connotation. So I was in the hallway talking to the debt collector. And by the way, don't even look over there. Debt collector, debt collector, debt collector. They don't have a name. They have a cause. And that cause is breaking the law and taking my money that they don't or can't prove they have the right to. Always stand. That's my next checkoff. How do you stand in a Zoom meeting? I'm crazy. There you go, I admit it. That's my one step. But I have a desk that rises, and even on Zoom, to be honest with you, it broke. So it didn't rise today. I had a court hearing. It's July 5th, and they made me go to court. I'm not complaining. But you don't sit. Why? Because the other side's sitting. It's another thing that adds up. Always be standing. Always let the court know you're standing. Eventually, if you do well, the court's going to go, "Just sit down, Mrs. Smith." So you do, but the fact that she noticed means she knows you're respecting her. And then when you're referred to or asked a question, stand up again. You're showing respect. Never miss a chance to make a good impression or make the other side look bad. It's a game of inches, people. The 3-second rule, that's your another checkbox. Wait 3 seconds before saying anything. And always take a deep breath first. In fact, do that right now. Take a deep breath. On the other side of that breath is a calmness. It clears the emotion and the anxiety out. And what you have to say comes out just as well. And it's not fraught with anger or anxiety or fear. None of that stuff helps you, all right? Another checkbox. Have your answer. Now, counter affidavit, that encapsulates everything and follows us all the way through litigation. Have your answer, their lawsuit, and your pretrial statement. You want to do a pretrial statement for the court, and it's easy once, and I've got videos on it. Let's do the video on how to do a pretrial statement. Boom, 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 bing. Anyway, so that has the pretrial statement video has lots of notes and examples, even if the court doesn't ask for it. Never miss a chance to make a first or a second or a pretrial impression. Send them a pretrial statement and then have it in your binder. Put pink sticky notes at very important places. For example, if the court asks you, "Don't you owe this debt?" and you say, "No, Your Honor," and we'll get to that on how to handle that question, but have a pink sticky note sticking out from the actual page or pleading that shows how you can show that they haven't met their burden of proof. So you're in the mess, you're in the actual pretrial. You just look down and see big words, no proof. So then you just go like this, "No, Your Honor." In fact, if you turn to page 2, makes you look good. Never miss a chance to make a first, second, pretrial during the pretrial impression. Have your statement about, checkbox, have your statement about your case be brief but full of content. Here's the best way. I'm going to modernize. I'm going to sound like I'm young or something. I'm not. But have your 1-minute approach that encapsulates your case, your defense, and why they suck in 1 minute. Pretend you're doing a TikTok. A TikTok is a 1 minute, and usually I do them, and you got to speed through them, but you got to fill it through a content so you give people value for their dollar. So have your impression that you want the judge to have about your case and their bad case be a TikTok moment. A TikTok moment. You got 60 seconds because you're going to lose everybody's interest after that anyway. So here's an example, and it's right on the checkbox. Your Honor, this is the case of the debt collector wrongfully suing me for a debt that they cannot prove they own. Indeed, their own paperwork shows a broken chain of title and that they have no standing to sue me on this debt. I just said a mouthful, showed them to violate the FDCPA, can't even write a proper complaint, all in a TikTok moment. So have a TikTok moment, all right, when you do this. I would ask that the case be immediately dismissed is how I end that TikTok moment. You're not going to get that. But suddenly people are paying attention. Well, you can't do that. Remember, if you're not represented by an attorney, you get leeway, okay? Because the judge wants to be fair, and we're all nice. We don't want to have this person be in a lion's den that they are in without guiding them. And the judge has to remain neutral, but you are a member of the judge's community, and don't forget that either. So give your best. You can kind of bend the borders a bit and say, I want this case dismissed. Now, this is not going to happen, but it puts you in control. Suddenly, the debt collector, that's the second time I said that, is on their heels. And now they've got to say, that's not true. Blah, 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 blah. So the judge may look at your lawsuit again. And if she is, well, how do you know that? Well, you just look down at your binder with the big note and go, look at page 2, Your Honor. That's control in a couple of ways. You're not a shrinking violet. We just have the natural human tendency to follow its evolution. We look at the weak and we're not so nice. So you're now taking control. And if you look like you're in better shape than the debt collector, it's the third time, then judge is going to notice. People are going to notice. He or she is going to notice. And the debt collectors are debt collectors because it's the least opposition to doing their job, to getting there at 9 and leaving at 5 and being home at 5:30 for the bourbon without worrying about their job. So be a problem. You know, I used to say this a lot. Be a problem maker, problem parker. Be a problem parker. They don't like anything that gets in their way, that there's no challenge in that job. It's a needed job, but be a problem. An educated consumer is their worst nightmare. So this case should be dismissed. They haven't met their burden of proof. They have no standing. They're not expecting you to be educated, and that's why you pop them. Now, the other side will go nuts at various points, but they're not prepared for you like you are. So use my top 10 tips on preparing for court. Have your checklist. You just roll over them, and it takes the nervousness out of it. I still use a lot of these things, okay? Here's a really good thing you want to do. Ready? This is the bonus, baby. I should do one of those videos where you say at the beginning, at the end, there's this great bonus, so you go all the way through. It's good for YouTube. I just don't have it in me. So anyway, but here's the bonus. Discovery. You're going to get discovery, and that's the court tells you how much discovery you're going to have. Ask for 90 days, and you want 1 deposition. But every bill of sale, look at my bill of sale video I just did for free, and prior to that, assignments and bill of sales, there's a couple of them up there. Whoosh, they're great, but every bill of sale says, let's just say it's UHG. Original creditor sold the debt to UHG. Any number of MCM, Velocity, whatever, PRA, they all have a bill of sale attached to the lawsuit. And it says the same thing, pursuant to the bill of sale or forward flow agreement or master service agreement or master purchase agreement. That's right in the bill of sale. So you're entitled to that. It actually says pursuant to the terms and conditions of the forward flow agreement. So in other words, the whole thing against you is pursuant to this forward flow agreement, which is never attached. It is a very secret document. It gives away things that you kind of, if you knew, half these cases wouldn't be filed. It's all an as-is relationship where the original creditor is saying, we're selling this crap, but we don't guarantee it at all. And in fact, you'll see a lot of times in the bill of sale say, without recourse or no representation, here, you take it. The forward flow agreement is like taking a pointed nail and jamming it into the root of a tooth of a debt collector. I hope I've made my point. They do not want that pain. They do not want to give that up. So what are you going to ask for? The forward flow agreement. So in discovery, you say, Your Honor, I want a discovery. I want to see their forward flow agreement. Miss Debtor, why do you want this? Look at the bill of sale. And of course, in your binder, bill of sale, forward flow agreement, pink note. It says right there, it's pursuant to. I'm not a lawyer, Your Honor, but doesn't that mean that the whole thing rests on this forward flow agreement? I'd like to see it, Your Honor. And they go ballistic, that case will get settled. Here's another pro tip. The judges are not always on your side. They're not they are neutral, but they are human beings. They bring their human experiences to the bench. You will get asked, but don't you owe this debt? As though that has anything to do with the fact of burden of proof or ownership of the person that sued you. You didn't sue them. What's she asking of them in that regard? It won't be that fair. This is why you're taking control. So if you're asked if you owe the debt, state the truth. Your Honor, I do not owe any debt to this debt collector, 4th time, and the debt collector, 5th time, has failed to meet its burden of proof to show I own it. So you've answered like an attorney, like a politician. You're staying on a message. If the judge pushes you to acknowledge knowing the debt, she'll try something like that. Don't get caught into the trap of her from then on thinking, well, you're just trying to get out of the debt. You say, again, and respectfully, Your Honor, because you always respect the bench, I do not owe anything to the debt collector, 6th time. I'm going to stop doing that. Who has not met its burden of proof of ownership to ask that question of me. She's the one asking, but you're kind of making it their question. So do not, if I thought that telling you, yeah, the best you can hope to do is, while I may owe the debt, Your Honor, and I haven't seen any proof because they haven't provided the proper proof, I don't owe it to this debt collector. You see me do that in many videos. But that's the truth. You always got to tell the truth. But also know that the judge is coming at you as a means to get you off her docket and put it in her head that you owe it and you're just trying to get out of this debt without knowing the facts yet. And that's another reason why you give her your TikTok version full of content. Content is a TikTok word. So know what you are saying. When you say something before the court, know what you're saying. Well, that's obvious, right? Do a little research. Now, the counter affidavit that all the videos I tell you about doing a counter affidavit, I've got a free PDF how to do the counter affidavit. They're all up there. And let's swish them off. Ready? Boom. So the counter affidavit is everything. As I always say, it serves you well. It follows every court session. And where does it come from? I have to do this once a video, by the way. Where do we get the content of the counter affidavit? Where do we get it from? What's my favorite expression? You got it again. Use their documents against them. So all their bad documents are in your counter affidavit, which is a tool for you, and it follows you. So if you're asked any question, you can basically answer from your counter affidavit. If you have an opening, another checkbox, point out any error. If they say something, they call you the wrong name, very common thing, or they say something that's just blatantly not true, point it out. Never miss an opportunity to point out the error of the debt collector. It's all about control. Asking for the forward flow agreement, being an educated consumer, taking control settles cases. Again, ask for that forward flow agreement. There's no reason why you can't have it. Never, here's a Parker nonsense tip, checkbox, never look at the other side. You will write notes, use your ears, don't use your eyes. You'll hear more than you will by looking. There's no point. Don't even legitimize that they're there. They're a debt collector. I'd move my chair if I could, if I was sitting next to them. You gotta tell the court, smile at the court. Who are these guys? So never look at the other side. Right. In the check sheet, I don't know if I'm doing this right, you got a little note section. By the way, at the beginning, this is important. It's going to be the first question you're asked when you go to court. In the beginning of the cheat sheet, I've got case number. Very important. Have your case number. Have the judge's name. It doesn't hurt once in a while to go, Judge Smith, blah, 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 blah. You're recognizing she's a judge and you took the time to know her name. It's just little things that eventually add up. How do we start? We start with a smile. A smile, a mile for the court. It'll take you a long way. How do we end? Guess how we end? With a smile. Tell the court, have a good rest of your day, Your Honor. If I see a loaded court, a lot of people in the court or on Zoom, I'll go, I hope the rest of your day goes fast, because we're all thinking that. And it's a nice touch. So look for nice touches like that, okay? So, and now look on my membership website, collectionstoppersolutions.com, of all the great stuff, but this is another free cheat sheet on how to appear in court and talk and get rid of the anxiety. So again, see my top 10 list and video for the prep work, and that's great, by the way. I was just reading it this morning, preparing for this. I'm like, this stuff is really good. Who wrote this? Oh, I did about 8 months ago. So it's a cool video. This is a cool video. Take this cheat sheet and every instruction I've told you to take to court, and do your best. Don't miss a chance to make a first impression. Thank you for watching. Like, love, and subscribe. Go check out that membership website. It's a great, easy monthly fee for everything you need. You just apply your state law and your facts. And again, that membership takes out the anxiety and the nervousness of going. I hear from people regularly every day, hey, I just won another case thanks to your video, blah, 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 blah. And it does help you. It's all about nervousness and emotion. This cheat sheet will take a lot of that nervousness and emotion away, and you'll do great. Thank you very much.